May it please your lordship. Lordship, with the consent of the other side, I beg to mention item numbers 3 and 4 of the daily list, lordship. Lordship, the learned advocate general appeals in this matter, my lord. There's some difficulty today, lordship. I pray for adjournment, lordship.
The date was given as per his choice.
Lordship, today is
These are the partnered matters.
yes, lordship. Lordship, maybe please you fix the matter next week, lordship. Lordship, next Tuesday or
Tuesday,
Thursday.
next Tuesday.
Like, deeply obliged. 20.
Item number 8 to 19.
May I please mention? I beg to mention for listing one application number, my lord. This was last listed on 24/8/2023. Here we are challenging the new rules, my lord. For that the Assam Secretary Service Rule 2019.
First week of July.
First week of
June.
July.
June. June. madam.
Yep. June.
May it please the lordship. Lordship, I beg to mention an item for listing. It last was listed on in the month of April, wherein it was directed to be listed after 10 days. But since then it has not been listed.
June first week.
Obliged.
For orders, item 1.
May I please, your lordship? I look the yesterday petitioner joined me, lord. Yes. Last me, lord. This is the joining and appointment order.
Then it concept the petitioner has submitted that the petitioner has joined on the post of which
Khal-
post?
Khalasi, my lord.
Khalasi.
Yes, ma'am. In the office of the
Pursuant to
executive
the-
engineer.
Pursuant to the appointment order passed by the respondents, full stop. In view of the fact that the appointment has been granted to the petitioner and he has accepted the same. No further order is required to pass in this contempt petition. The same is therefore disposed of.
Deeply
Notice is discharged.
Deeply obliged.
Item 2.
May please your lordship. In this case, Mr. R.P. Sharma, senior counsel is to argue the matter, lordship, but he is suffering from eye problem, lordship, after the surgery. Lordship, can it be taken up after a week, lordship?
It is maintainability is under question, but since my lord, the adjournment is not on medical ground, my lord.
Whose credibility in the question?
No, means maintainability is.
Maintainability in question.
It relates to service matter, my lord.
You will argue, Mr. R.P. Sharma will argue.
But since my lord,
After summer vacation.
Obliged.
can I pray for a firm date, my lord?
After summer vacation, whatever they.
Item 5.
We have challenged, my lord, the judgment and order passed by the Honorable Single Judge, my lord, dated
23rd of June, 2023.
yes, my lord. So there is the judgment start from page 217, my lord, 217.
Yes.
Yes, married, my lord.
Yeah.
My lord, from paragraph 3 onwards, we may, my lord. It has further been projected that on 28/10/2010, the respondent 4F5, there is a present appellant, has filed an application before the Additional Deputy Commissioner Revenue Jorhat for correction of Jamabandi. On such application, the authority registered a case against the predecessors of the petitioners and issued notices to them. It is the case of the petitioner that much prior to the time of institution of the proceedings before Revenue Authority, the predecessors of the petitioners who were the original owners of the land in question.
Mr. Counsel, you straight away come to para number 26.
The rival submission of learned counsel for the parties have been duly considered and material on records have already been carefully examined. The issue which has arisen for determination examining the correctness and validity of judgment and order dated 19/9/2020 passed by learned Assam Board of Revenue, whereby the order passed by the additional Deputy Commissioner Jorhat declaring ownership in favor of the respondent 4 and 5 has been upheld, may be jotted down as follows. Whether the proceeding initiated before the learned additional Deputy Commissioner under the Act 1971 was in accordance with the law, whether the proceeding was valid proceeding which was apparently instituted against the dead persons, whether the participation by the petitioner in the said proceeding would do away the requirement of making necessary and affected persons in the proceeding, whether the approach of learned Assam Board of Revenue while dismissing the appeal and deciding the various issues is in accordance with the law. The Tenancy Act 1971 lays the provision of Section 23 by which a tenant can seek the ownership of a plot of land on certain conditions. Rule 9 prescribes the application should be in a particular format, being form number 5, which is required to be signed and verified. However, it is seen that the application dated 28/10/2010 by the respondents 4 and 5 is neither the prescribed format nor does it contain any verification. That apart, even if this issue of format is overlooked, the same does not have any verification, which is a substantive requirement. It is also seen that publication of required under Rule 13 has not been done. Under such circumstances, it is difficult to give an endorsement of legal sanctity to such procedure. As regards the issue of filing of the case against the dead person to examine the same, some relevant as well as contemporaneous materials are required to be considered. The predecessors of the petitioners had passed away before 1981 when the Jamabandi was corrected and the names of petitioners were recorded. It is after about 30 years when the respondent number 4 and 5 had filed the application on 28/10/2010 purportedly under the Act 1971. The respondents had claimed that they were tenants in possession and yet the application was filed against the predecessors of the petitioner who had expired about 30 years ago. The notice issued by the additional Deputy Commissioner as would appear from the annexures to the lead petition, it is admittedly against the aforesaid dead predecessors. At no point of time any attempts were even made to substitute the respondents by their legal heirs, even after authority as well as the respondent number 4 and 5 was informed about the death of opposite parties. This court is also unable to accept the findings that notices deemed to be served as even endorsement showing receipt of such notice states that the concerned opposite party was already dead as the prefix late was used before his name. It is settled principles of law that notices can neither be issued to a dead person nor can be accepted by anyone on his behalf, more particularly when such notices are of legal proceedings. The landmark case of Honorable Supreme Court of Hiralal Patni Supra, which has been cited as follows. So this is the landmark, the validity of a decree can be challenged in execution proceeding only on the ground that the court which passed the decree was lacking in inherent jurisdiction in the sense that it could not have decision of the case because subject matter was wholly foreign to its jurisdiction or that the defendant was dead at the time the suit has been instituted or decree passed or some such other ground which could have the effect of rendering the court entirely lacking in jurisdiction in respect of subject matter of the suit in over the parties to it. The said provisions has been uniformly followed in all later decisions which have been referred to above. From the order dated 28/6/11, it appears that Additional Deputy Commissioner Jorhat, though observed that the original pattadars were deceased, notices were issued to the legal heirs of the original pattadars. This court is the opinion that unless the writ petitioners who were present pattadars were substituted in place of original pattadars and were made parties, question of issuing notice to the writ petitioner cannot arise, and therefore the entire proceeding against the dead person is nullity and non-est in law. With regard to the issue of reliance upon the photocopies of documents relating to Khotian, the learned Assam Board of Revenue has made the following observations. I have also perused the arguments put forward regarding the photocopy of copy and submitted, etc., and find that these arguments do not hold. There is a clear indication that these documents in original were perused and found as acceptable in title suit number so and so in court number Munship number 1 Durhat. The aforesaid observation is not in consequence with the law of evidence, though photocopy of document can under certain circumstances be exhibited as secondary evidence. There is a procedure prescribed in law for such course of action. In the instead case, there is not even a semblance that any procedure was followed in this regard, and therefore reliance upon a photocopy of a document with the aforesaid observation that the same was filed in civil court, that too in a suit substituted by a third party, is a wholly erroneous approach and not sustainable in law. The case laws cited upon by Sri Bora are clearly distinguishable from the case in hand. In the case of Himmat Singha Motor Works Limited, Supla, which has been cited with regard to the issue of notice, the facts in the case was in connection with the date was not given in the notice, even whereafter the opposite party had appeared, and therefore the issue was rendered redundant. In the case of Bikram Fukan Supra, the notices were received by family members of the respondent who was still alive. Under the aforesaid facts and circumstances, this court is of the considered opinion that the entire proceeding initiated before the additional deputy commissioner in TSA case number, which had culminated in order dated 28/6/2011, and the consequential order correction Jawabandi dated 11/7/11 are unsustainable law, and therefore the appeal preferred by the present petitioners could not have been dismissed by the learned Assam Board of Revenue, but impugned judgment and order dated 19/9/2020, and accordingly the same is also set aside. Consequently, the names of the present disputants are directed to be restored in the Jamabandi pertaining to the land involved. Now, my lord, the original order passed by the learned additional deputy commissioner, that may kindly be seen. Yes, that is page 140.
140.
Yes, 140.
Yes.
Yes, madam. The first party here, the petition, the first party and the learned advocate present in submitted attendance. Opposite party, that is the lead petitioner, is absent, but their learned advocate is present at submitted attendance. The brief history of the proceeding is that the first party is the petitioner Sri Nityananda Gogoi and Deveshwar Gogoi, both sons of late Putu Gogoi, prayed for ownership right on a plot of land measuring so and so, so and so, so and so, so and so, so and so. By petition dated 28/10/2010, submitted along with, this is the my lord, submitted along with form number 5. The Honorable Singhas held that there is no application filed under form number 5. As per provisions of Temporary Settled Areas Tenancy Act 1971 and under section 23 of the said act. The father of the petitioner now deceased, late Putu Gogoi, was awarded tenancy right. This is very important.
Acha, Mr. Das and Mr. Sinha, the learned single judge's order is based on primarily 3 points. There is no proper verification. Notice was sent to dead person.
Yes.
And the it was not in format. Anyway, format, the single judge has diluted it. But the problem we find is that there is no liberty granted to proceed afresh. The entire matter has been brought to an end. So on a procedural ground, the order is set aside. And at the same time, no remedy is left open for the appellant. So we are proposing this order, subject to what you say, that will not interfere, but will grant liberty to the appellant to move a fresh application. And it can be decided by following the due process of law in the light of the observations made by the single judge. Because it cannot be brought to an end. These are procedural grounds that cannot take away their right to seek correction of record.
I can give an answer if your lordship wants. Okay, why this particular, I am supporting the judgment of the learned single judge. Why? My lord, I think correct picture has not been projected before this court. My lord, I'll just give a brief background. 79, my father expired. 80, my mother expired. So 81, the records of right was corrected because right of inheritance. That's 81. First ground, after 30 years, he files an application for Deputy Commission, claiming ownership right under the Tenancy Act. After 30 years, this is number one. And if your lordship kindly look into the application, no explanation on what ground after a period of 30 years he is approaching before the. Yes.
Mr. Das, that's right. Whatever whether he has a right or not, that's altogether other thing, another thing. The learned single judges primarily allowed your petition on the ground that these procedures have not been followed.
Deputy Commissioner's order was bad.
Deputy Commissioner has not followed this procedure. Suppose that notices to the dead persons, but no alerts have been taken on record. Verification was not there. Photocopies relied upon. The documents were relied upon, or these things. But ultimately, his right, whatever his right may be, he may be right or not. So far as regarding delay is concerned, you can very well raise this point before the additional deputy commissioner also. And so on, whatever the grounds available to you, and he can, he is entitled to move an application seeking tenancy rights, rightly or wrongly, that is to be decided on merits.
Yes, my lord, I'll just.
30 years, 40 years or whatever.
No, that's
maybe you
right.
Take your
My lord,
possible grounds.
I'll just give a reply. My lord, just your lordship permits me.
Yes.
My lord, 30 years is one of the ground,
Yeah.
but when you file against a dead person, his application is against a dead person.
Yeah, that's right.
Now he's saying
That's
that
why
he
only,
received
that's
a
why only
notice.
this order was set aside.
No, my only is that could not have happened because if a person was living and then only it can be substituted. It is not, you file against that person, his argument is that you appeared.
Now, in the fresh proceedings, he has to meet parties who to the persons who are now khatedars. And if he is seeking khatedari rights over a particular piece of land, then he has to claim whatever the right against those persons who are in possession or whose names are there in the record of rights. My lord says rightly pointed
No,
out
that's
that
my lord.
all the
Your
process can't
lordship,
be halted.
my lord, my honorable justice Pyami also is only worried because the procedure, that's what I understand, that procedure has to be, at least a chance would have been given to him. That's only the anxiety of your lordship, that procedure.
Since if he has any right, whatever it may be, certainly he may or may not have any right, but he can move in a fresh application by correcting all these, whatever the procedural irregularities or illegalities are there. And if he is entitled for that, the court will adjudicate it, and after giving opportunity of hearing to the other
For
side.
last so many years with this particular litigation or
Even
fighting.
though so many years,
But
whether
all chances, my lord, it is not an ex parte. All chances.
is there any bar a person can seek
No, it's
secondary
there.
rights after so
No, my
many
lord,
years?
My lord,
Then
what I'm on is a chance was given to him. It is not a chance was not given to him. Chance was given.
What-
Chance was given because he made us a party. We objected. There is an objection. Objection was taken into consideration.
that's why only this order of the additional commissioner was bad in law, and that has been set aside by the court. But certainly his right to claim tenancy in accordance with law can't be halted, sir.
No, he has
That can't
claimed.
be stopped.
No, that's true, my lord. He has claimed. He has claimed his right. But he's claiming his right after coming so many.
Mr. Das, according to you, does your opponent have a right to claim tenancy?
No, he
Or
may.
he
has
may.
claimed- He has claimed.
No. According to you, does he have that right or not?
He may have a right. I am saying.
Correct.
he
One
may
minute,
have a
one
right.
minute. That the fact that he may have a right
Yes.
and that right is recognizable or not. Where is the finding of the learned single judge on that point?
Let's, my lord.
Where is it?
Finding of the learned.
No
single-
delay, no procedure, nothing. Only on the merit.
Let us first look the application which we have filed.
No.
original
Finding,
application.
finding of the learned single judge on the merit of the claim.
Yes, let's see, my lord.
Yes.
Kindly see the finding.
Yes, on the merit.
My finding, my lord. Which is started from,
Yes.
my lord,
Number
will forget
26.
that, my lord, 226 is the finding. 228, 226.
Hmm.
It starts from paragraph 28. Para 28.
Yes.
The Tenancy Act 1971 lays down provision in section 23 by which a tenant can seek the ownership of a plot of land on,
Yes.
my lord, your lordship has decided, then
No,
I-
we are simply proposing, subject to what he says.
Yes, my lord.
that's,
Yeah, the
Your
only-
lordship.
only point here is we are granting that all the findings of learned single judge on violation of procedural safeguard is correct. Even then, a certiorari will have to be followed by a writ of mandamus. Where is that mandamus here? Having set aside the order, the whole thing has been brought to a halt. That can't be the case.
But-
that you will agree.
no, that's right.
No, the procedure is not, he's claimed tenancy
that
right. This was granted,
lord,
the procedure is not followed,
that-
we set it
that
aside. That's
procedure-
all. That can't be the way.
No, that procedure, I understand, my lord.
Yes.
2010,
We are only on that.
no, it's right, my lord. That means your lordship, he'll get reopen the entire case. He is getting reopening of the entire
Subject
case.
to
He-
an application is moved by the persons who are seeking tenancy in accordance with law.
Yes, my lord.
Subject to this, we are not opening. It is up to him. Up to the petitioners or appellants in the writ petition, they may file an application or they may not.
That means, my lord, he gets an opportunity also. After 30 years, he gets an opportunity to
Sir,
reopen the entire
is there
case.
any bar?
No,
Is
my
there
lord,
any
your
bar?
lordship,
In
time
the
and
law
again.
that after
Your
15
lordship-
years, 20 years, 30
your
years,
lordship
nobody
is-
can claim
no, your
tenancy or
lordship-
ownership of the land?
Well, on and often. My lord, my lord, normally I will not object to because what I'm, no, this will open a Pandora box, my lord, everyone. No, 20 years, 30 years, normally your lordship always ask to us that why you have come after so many years.
That is
Delay
a,
latches.
that is a valid consideration. and
Delay
it can be-
latches.
It can be taken into or objected by the court in every case or in any other case. But certainly if there is any provision that no person can claim ownership after so and so years, you just show us. And certainly he has no right.
Then I will just look into it that whether that particular provision, whether because there is a provision on a temporary settled areas, 1971, ones can claim an ownership right. So if that provision, I have to look into it, whether it is barred or not by looking into that provision, my lord. Because that was issue because we just argued the matter on the ground that there was delay. Now your lordship is asking whether under the statute there is a provision or not.
We are just asking because you are raising this question.
No, I am
You
raising-
can't grant them the opportunity.
No, your
Opportunity
lordship-
can't be granted to
But-
them to
No, my lord.
initiate fresh proceedings for the purpose of ownership. Is there any time limit
I
for
will-
that
I-
purpose? Yes.
I mean,
certainly,
I,
not
I,
grant.
I will look into it, whether there is a bar, whether there is limitation point or not on this ground. If there is a bar limitation, then of course, my lord, that your lordship.
Then
just-
it will extinguish his right.
Yes.
Otherwise, his right has to be answered on merits by some forum. The revenue board has gone into it, but the learned single judge has not made a whisper on.
No, but
Learned single judge has found him, has non-suited him on procedural grounds, not on merit.
But-
So it may be a case that on merit he is entitled, but because there is no verification, there is no proper service. There may be less. That's the point.
I will look into it, whether there is a provision under the statute under 1971, 71.
lots of provisions.
If this right extinguishes, there is a provision
Then-
bar
then-
limitation, my lord.
Yes.
How many years? After how many years he can
Yes,
approach?
yes.
That's the point, my lord.
This writ appeal is.
The ends of justice, I understand. Normally, when we are before this court, we are always cautious because the point raised by the honorable court is on the limitation. Delay latches after 30 years. He
That-
makes an application. And kindly
No, no,
see.
sir, if there is no prohibition under the law that a person can't claim tenancy after so many years, certainly there is a point. But if there is no such limitation, then it is always.
There is
open
no
for a
such
person.
provision, man. No, nothing is mentioned.
I will
For-
not just comment on this. I have to go through it and I have to.
Yes,
make-
Tenancy was from his father, from his time of.
This writ appeal is
Fine.
filed by the appellants being agreed with the order dated 23/6/2023, passed by the learned single judge in writ petition number 4749/2020, whereby the learned single judge has allowed the writ petition and set aside the order dated 28/6/2021, passed by the additional deputy commissioner, which is that Jorhat, and the Board of Revenue and the order dated 19/9/2020, passed by the learned Board of Revenue. The learned single judge has set aside those orders mainly on the ground that the procedure prescribed under the law for claiming ownership has not been strictly followed in the proceedings before the additional deputy commissioner Zorhat. Full stop. It is noticed that the learned single judge has not given any finding on the aspect that whether the appellants have a right to claim ownership under the Tenancy Act or not. Full stop. Learned counsel for the respondents raised some time to apprise the court that whether there is any time limit under the law for a person for claiming ownership of a land. Full stop. of a particular piece of land. Time period for is granted, list. How many days?
No, after 2 weeks, after 1 week also it can be.
After a week, next week.
Point is a small point here.
Obligement.
Clear.
Item number 6.
And the last occasion, the chief director, the finance department to
Yes, Mr. Naik.
Lordship, as per my instruction, Lordship, a proposal was received in the finance department, but it was returned to the department, Lordship, health department.
With some queries.
Yes, Lord.
So what happened to that?
Thereafter, it has not been resubmitted. Lord.
By what
Not a
time?
basic issue in this matter, Lordship.
Yeah, go through that. Whether there is some, this regarding pay scale.
pay scale,
Lordship,
regarding pay
one-
scale.
Regarding pay scale of the
Lordship,
diploma holders
Yes.
and the
Lordship, in one
And the
cadre,
BSc degree, my lord.
in one cadre, some are
BSc qualification
BSc
or diploma
qualification, some are
qualification, then
different. And
whether
BScs
there
have
can
been
be a
given higher
disparity
scale.
in between the pay scale or not? This is
Yes.
what the question.
That is
That's
the
okay.
only.
Yes.
Well, in 2019 rules, madam. 1990 to 91 rules, madam. There is no difference, madam. And can you page 33, madam?
So, Mr. Nayak, what are
Even
your
when-
instructions? On the last occasion, you said the finance department has submitted some query, was received from the health and welfare.
That is
department.
what,
Therefore, he
Lordship,
wants
that
to
file
complete
has
his
not yet,
instructions.
the department has not yet resubmitted that file, Lordship. We are waiting for even on 9th of April, Lordship, we even one issued reminder also. Lord.
This is of 22nd of April, two thousand
Lordship, it
twenty-four.
was prior to that, Lordship. The same setup. Today morning also I took the status, Lordship, it is same, Lordship.
Then they have not given any instructions in that.
Lord, no, Lord. Once the file is resubmitted, Lordship, will definitely take some time.
This is the dynamic. So maybe step here. According to the category.
91, 33.
इसमें जो दिया है उसके मुताबिक अपने मेन रूल को
50.
they are challenging the RFP.
Into plus.
सवाल है कि we wait for this
Second
topic.
rule, but
Decide to make it.
Complete your instructions, Mr. Otherwise, I will consider it. But it seems that
Madam, again, on earlier occasions also you also directed, madam. Last 1 year, madam, they're pending the matter.
so you want to decide this matter on merits.
Otherwise,
We are ready for that.
department has already filed affidavit, madam.
Whatever the health department has filed the affidavit, where is the finance department objecting to it? So, what do you want? Till wait for instructions or you want the order on merits?
But they may file affidavit.
Then why you are objecting? Okay. Then it concept, Mr. P. Naik, the finance department has submitted that he is not in receipt of instructions from the finance department till date. He placed some more time. Time period what is granted. What time?
Lordship, one affidavit I have already filed, Lordship. Subsequent there to proposal was,
Now, on the last occasion,
yes, Lord.
You said that you have already requested to change in the rule, this act
Yes,
itself.
service rule, they drop service rule, change
Yes.
some changes in the drop service rule.
Updated in
Updated
Yes, sir.
instructions list on. June.
Deplore.
Item 7.
Mr. Kumar,
Yes, madam.
hospital has already been constructed,
Madam.
medical college in operation. What remains in this petition now?
Still, my lord, without looking into, your lordship can have an audit of there, whether it was done as per specification or whether there is any financial.
This is once the hospital is already, this construction, building construction is already over and the medical college is operational. We don't
But
find
it is,
any.
it is because of this PIL that has been expedited.
You may file,
Ah.
that's right. That's better.
Yes, my lord. We have to see the.
Constructed the medical
But
building.
still, man, I'll leave it to the wisdom of your lordship. It's not that the quality of construction cannot be checked now, or whether there are financial irregularities or not.
If you have
that-
any objection regarding that, after construction, the quality of construction is not good or it is not up to mark, you can
But that's
again
what,
file a petition for
but
that.
that's what have been raised in this petition regarding the financial irregularities
But
and the.
since now this construction is over, we are not inclined.
I'll leave it to the wisdom of your lordship, my lord. I can only,
Okay.
because this is a adverse.
Right, okay. This writ petition in public interest is filed by the petitioner essentially raising a concern about the condition of the building of the Nalbari Medical College and Hospital. Full stop. It is contended in the writ petition that the construction of the building is not being carried out as per the specifications and the time limit for completion of the construction has also not been adhered to. Full stop. Then it consequence the respondents have has informed that the construction of the building is already over and at present the medical college is functional. Full stop. Taking into consideration the fact that the construction of the Nalbari Medical College, Nalbari, the construction of the construction of the building of the Nalbari Medical College and Hospital has already been completed and the medical college is in operation. We are not inclined to interfere in this matter at this stage. Hence, this PIL petition is disposed of.
My lord, your lordship will kindly grant us the liberty to approach the appropriate firm in case of the financial irregularities and not following the specification, because others.
We have not prohibited you.
But
We have
that-
simply disposed of the
but
petition.
otherwise, this order will be cited in every proceedings, then that this matter was.
That altogether you are raising a altogether different point regarding financial irregularities or whatever it may be. Since the construction of the building is over, we are not inclined to entertain this. It's all.
Item number 8.
रोल लगा और हमारे सामने लोग सामने दिवे ना दिवे क्या है
Lordship, on last occasion, Lordship, I took time to receive instruction.
Yeah.
Lordship, on last occasion, I took time
Yes.
to receive instructions of whether he can be released or not, whether there is, but the instruction is not encourageable for the respondent, Lordship. Don't seems to be encourageable, Lordship. The willingness is missing, Lordship.
Willingness of,
Releasing means to
so the
some other-
department is not willing to release him. For what?
Lordship, the reason given is because Lordship, he is right now engaged in three project, Lordship. The second is that Lordship,
He is a liaison officer.
no, Lordship, this is a demanding officer, Lordship.
What is?
What they have stated is he is a demanding officer. He is looking after is a brainchild of that. According to them, it's a brainchild of the project to which he is associated, Lordship.
Brainchild. What is the project, by the way?
Three project he has been involved,
What's
Lordship.
the project?
Lordship. One is dehydration tablet, manufacture of dehydration tablet, Lordship. Development and demonstration of visual camouflage technology. The second is Lordship sound elimination standard issue. That is while removing the sounds while the guns are cocked, Lordship. And the third is-
By the way, he is a graduate of biochemicals or
Lordship,
something.
Lordship.
So what to do with the noise and biochemical?
The perhaps related with the ballast and all, Lordship, maybe. The third is Lordship, development of hydration tablets, Lordship.
This civil transfer.
This is what this 20th of May 2024.
Lordship,
This is the communication, latest communication.
Lordship.
Completely high-ended.
You have already filed an affidavit that he is involved in so project.
Lordship.
Where is that?
No, Lordship, last time not affidavit, Lordship, one instruction, Lordship. It's a piece of paper, Lordship.
We filed an affidavit, my lord.
You filed an
We
affidavit.
have enclosed.
Yes. Where is your affidavit?
Filed on, my lord, 10,
13th of May, 13th of May.
yes, 10/5, 24 we filed.
Yes.
30, yes.
What is the order of the cat?
150,
One?
155. Oh, not 150. 132, sorry.
132, Lordship.
132.
This order is at page
132,
132.
yes. 134, wait. This is for the third time, my lord, Planet Cat has allowed the matter.
This paragraph should be coming to
That's all.
Lordship. Lordship, only the matter of concern is Lordship. In case the Lordship held that the tickets order Lordship, that OMs which restrict the tenure posting to 3 years, the other may pour in Lordship.
Certainly, if they are
dear
entitled
Lordship-
to, then that's why only we gave you chance earlier. We consider his case, otherwise we are going to pass an order, but you said, no, we are not going to pass an order, then you have to face the music.
Lordship.
Lordship, that's all what we can say.
Lordship, two decisions I'd like to rely. Lordship.
Yeah.
you consider
Specific whether this judgment is applicable, these amendments are applicable or not. So ये कह रहे हैं नहीं सब हमारे को पता नहीं जजमेंट
yes. Page 132 is the order under challenge.
Lordship.
What is the proposition, Mr. Chakravarti?
Lordship, in the SK Naushad case, Lordship, I'll be relying on paragraph number 24 and 25, Lordship.
24 and 25.
24 and 25.
Yes, read.
First, paragraph 24, Lordship. First and foremost, transfer is an all India service, is an incidence of service, whether and if so where an employee should be posted on matter which are governed by the exigencies of service. An employee has no fundamental right or for the matter a vested right to claim a transfer or posting of their choice. Second, executive instruction and administrative directions concerning transfer and posting do not confer an indefeasible right to claim a transfer or posting. Individual convenience of persons who are employed in the service is subject to the overarching needs of the administration.
So in that case, he was
The OM
opposing the person was opposing the transfer.
No, Lordship, but he relying on that, he wants to,
Whatever it may be, he was opposing his transfer, that
But
he
the-
can't be transferred.
but the ratio is, Lordship, that is,
This will consider close for orders.
My lord, just one submission I want to make, my lord. They have approached this honorable court, my lord, twice on the plea that these two OMs are not applicable. But the impugned order, which was challenged before the CAT, my lord, honorable CAT, that does not speak a single line about that, my lord. So CAT has adjudicated at the second time also, they have adjudicated it as the honorable High Court has directed. That's.
obliged.
But this is for admission, but you don't have admission.
Supplementary list, item 30.
The matter is already.
Wait, legal lordship.
Which are the other matter, other cases? 27, 29. Other matter to other matter to.
Yes,
Lordship, the counsel for this, the appeal supposed to be on VC. I mean. He's
So-
supposed to be on VC. Yeah.
yesterday he appeared.
We are supposed to serve the notice and we have served it today itself.
All right, you call it up with the other matters.
Any notice? Oh, this is the- Timing good?
Item 31.
May I inform past Malad that for IRCTC, I am appearing, the refreshment group has been vacated on 20th, 20. I got it.
Yesterday, my lord. My lord, may I make a limited prayer, my lord, at this
Yeah.
stage? My lord, this refreshment room, we have been continuing for 5 decades, my lord, since my father's death, my lord, till date. Now, my lord, I have come to know from my learned friend that the earlier NIT is not, it has lapsed. So they are supposed to float fresh this NIT. So, my lord, may I make a prayer, my lord, since I have to also make arrangement, alternate arrangement. Can it be possible till they float the tender, my lord, I may be allowed?
Once it is vacated, it is vacated.
And they are renovating, my lord, the extension is upgraded, my lord. Now, as per the government of India policy.
Yesterday also, my lord, I
do
approached
renovate.
before this honorable court, my lord, but could not be listed. So, my lord,
Not be listed, not for.
yes, lordship did not allow.
You
My
paid
lord.
for listing of case and we have ordered for listing today only.
Yes.
Yeah.
Yes, but my lord, we had approached the authorities to wait for a single day, my lord. But that,
That's it.
my lord, I only pray, my lord, whatever the railway authorities will be doing, my lord, till then I may be allowed, my lord.
Now there's no stopgap arrangement.
My
It
lord,
is
I
there.
pray, my lord, because my livelihood is
If
also at
it is
stake.
already vacated,
Yes,
then we can't permit them again to open it and allow you to continue.
my lord, yesterday only they have put a
You
law.
argue on the merits.
Yes.
You argue on the merits, yes.
My lord, here,
He can submit the tender, my lord, when it will be- press tender will be issued after renovation.
my lord, I just point out two things, my lord.
Because renovation
Yes.
will be going.
My lord, this phrase license was, the tripartite agreement was entered upon, my lord, in the year 2017. There, my lord, no date was fixed of the expiry. And my lord, till November 2023, they have been taking my license fees. So I have that impression, my lord, implied impression, my lord, I am being
But
allowed.
it is for indefinite time.
My lord, I understand, my lord. So, my lord,
Can't be.
my limited prayer right now is only to that extent, my lord, sometime may be allowed, my lord,
For what?
for allowing me to run, my lord, till they finalize, because they have not
They
finalized, my
want
lord.
this renovation and all.
My lord,
You can't be allowed.
my lord, I will just point out one point, my lord.
Yes.
Division bench order, division bench. Go to 18. At 135, my lord,
Yes,
135 onwards, my lord.
yes.
These honorable bench, my lord, division bench. Earlier, my lord, on occasion, my lord, that is at 138.
Yeah.
138 onwards, my lord. Last paragraph, my lord, it says, my lord, however, at this stage, Mr. G.N. Saiwala, Lord Senior Counsel appearing for the respondent, submitted that the present writ appellant is running one refreshment room along with a tea stall and a dala in the Rongia railway station. It is also submitted that fresh tender process was initiated only in respect of the refreshment room at Rongia station, and that the same has been finalized. But now, my lord, when I pray for a, requested for a copy of the finalized that in the NIT, my senior friend said, my lord, that has been cancelled.
Okay, fine. Again, they'll issue a fresh, and you apply for that. What's the problem in that?
My lord, till then, my lord, because
Sorry, sir.
that is my limited prayer, my lord. I leave it upon your lordship, my lord.
Issue notice, Mr.
My lord, otherwise
Sahiwala
the
put in
petition
appearance
is
on
pending,
behalf
my lord.
of respondent number.
I'm for the phone number 2, 3, and 4.
2, 3, and 4.
Yes. He is appearing for 1, 5.
And Mr. Gupta is appearing on behalf of respondent number 1 and 5. Copy, आपको you are receipt of copy, writ appeal.
Yes.
So they may file their
My lord,
response by the next date of hearing.
at that occasion, I would like to withdraw because otherwise, my lord, the writ is pending.
Writ is pending.
Yes.
Okay, wants to withdraw this writ petition, dismissed as withdrawn. Yeah, writ appeal, dismissed as withdrawn.
Deeply obliged, my lord.
Daily list for hearing, item 9.
Made prisoner. Lord, in this case, we have challenged the virus of 3 rules, my lord. Just to give a glimpse of the problem, the lordship should kindly come to page 84. In a graphical form, we have given the hierarchy of the posts. Page 84, my lord.
Yes.
Now, earlier there was no rules framed under Article 309. There was a service order framed in 1990 which was subsequently amended in 1998. This is how the position stood. Now there are three wings: engineering wing, planning wing, and research wing. End of the day, my lord, the entry level in each of the post was assistant engineer, assistant director, and assistant research officer. And eventually, my lord, they had the opportunity, subject to acquiring qualification, to reach the pinnacle, that is the post of director. Now, if your lordship would kindly come to page 86. Now, following the framing of the rules, this is the position which emerges now. The engineering wing, they can at best aspire to become superintending engineer. Assistant research officer, research wing can aspire to become as senior research officer. It is only the planning, my lord, wing which retains the, preference of climbing to the ladder of director. But this is the position.
So the engineering wing, research wing,
They do not have now the possibility of reaching the grade of director. They will retire either as superintending engineer or senior research officer.
and only they, this,
As planning wing, my lord, they retains the, they can climb up to the post of director. Now, if your lordship will kindly come to page 51. This was the schedule to the amendment carried out in 1998. So joint director was equivalent to superintending engineer. Deputy director was equivalent to executive engineer, senior research officer. Research officer and assistant director was equivalent to assistant engineer and town planning assistant. Now the three rules which have been framed, which your lordship will find at page number 93. This is Town and County Planning Engineering Service Rule 2016. It covers the case of engineers only. And if your lordships would kindly come to page 94. On top. The service shall consist of the following groups and cadres. Group A cadre, it shall include the cadre of superintending engineer. So no avenues for promotion to the post of director. So this is as far as Milord engineering wing is concerned.
these petitioners are both from the, this.
Yes, petitioner is from the
Engineering and
engineering,
research
engineering
wing.
engineering, my lord, not research. We are only engineering wing is before your lordship.
Researcher, the research
No.
people are not asking for
They
that.
are, they are not before your lordship. Then lords will kindly come to page number 104. that is the Assam Town and Country Planning, Town Planner Service Bill.
Yes.
Now there, my lord, if your lordship would kindly come to 105. Here the cadres include director, joint director, deputy director, assistant director. And as far as this research wing is concerned, the relevant rule is at page 112. And at page 113, the highest they can aspire for is senior research officer.
Earlier, it was a composite cadre.
Integrated, yes, it was an integrated or composite one. The government filed an affidavit in an earlier litigation where they used the expression integrated cadre. I'll come to that. Now, my lord, earlier what had happened, there was a litigation before this honorable court. The judgment which your lordship will find at page number 75. Where the appellant's promotion as superintending engineer was challenged by an officer of the planning wing. The learned single judge allowed the repetition against that. A writ appeal was preferred. And at page 80, lordship will find, this is the judgment. Page 80, after quoting the schedule, at page 80. We find from the above that the post of superintending engineer is equivalent to joint director. The same can be read harmoniously with provisions of para 8.86. Moreover, in affidavit dated 3/11/09, filed on behalf of the state in this appeal, the stand of the state is that both the posts have been treated to be equivalent. Stand of the state is that the appellant is also eligible for the post of director. In this view of the matter, we have to hold that petitioner is eligible for promotion to the post of director. We do not find any merit in the contention raised on behalf of the association that the two posts cannot be equated. Creation of post is within the purview of the concerned authority. Unless exercise of power is illegal or arbitrary, which has not been shown to us, the same cannot be interfered with. Accordingly, we allow this appeal and set aside the impugned order passed by the learned single judge. But my lord, we have filed an additional affidavit on 14/5/24. I think it must be on record, where we have brought on record an affidavit filed by the department. This in that very case, my lord, I'll just have your lordship's kind attention to two paragraphs, paragraph 3 and 5, at page 141 and 142, my lord. And this starts at page 132. My lord, in the judgment which I have read, the honorable court referred to an affidavit. This is the affidavit.
In writ petition number 4042.
No, no, my lord, an affidavit was filed in the writ appeal 128 of 2009.
Mr. Chaudhary, you have annexed it in the additional affidavit
Yes.
515.
Yes.
The page number is not correct. It's not 142. It will be 180. Page 180. 180.
I'm sorry, I think we have made some wrong designation, my lord. Please come to that affidavit filed in writ appeal, just two paragraphs, my lord, para 3 and 5. Has your lordship got it mentioned?
3 and 5.
Whom is it?
Yeah.
Yes. That with regard to the statements made in paragraph 3 of the writ appeal, the humble deponent begs to state that it is a fact that no service rule as required under Article 309 of the Constitution of India has yet been framed for the officers and other employees of the Directorate of Town and County Planning, Assam. But a service order regulating the matters of conditions of service for officers of the Directorate of Town and Country Planning was issued in 1990, which has been amended in 1998. The said service order is known as the Assam Town and County Planning Service Order 1990. Appointment and promotion over the year to the state service are governed by the service order mentioned above. The above mentioned service order was notified by dated so and so. From a reading of the statement of objection reasons of the notification and very title of the service order, it is clear that Assam Town and County Planning Service is an integrated one and not independent from each other on the basis of segment within the service. I just wanted to have a lot of kind attention to this. Then please come to para 5, same page. That with regard to the statements made in paragraph 7 and 8 of the writ appeal, the humble deponent begs to state that under Schedule 1 of the Assam Town and County Planning Service Order 90 as amended in 88, the post of superintending engineer has not only been equated with the post of joint director, but has also been included in the cadre of joint director as per insertion in column 3 of the same schedule. For the promotion to the post of director, town and country planning and officers shall be required to have served continuously in the cadre of joint director for 2 years. The post of superintending engineer is in the cadre of joint director as mentioned above, and the appellant of the instant appeal is holding the post continuously from 1/7/2006. The post of director has not yet been filled up as per the provisions of subparagraph 1 of paragraph 11 of the service order of 1990. Respondent number 3 in this writ appeal is holding the current charge of director by the order it is transferred. Therefore, the post of director, town and county planning is vacant for the purpose of subparagraph 1 of para 11 of the order of 1990. Matter of the appellant may come up for consideration along with etc. Basically, the stand of the government all along was that it is an integrated cadre and the promotional avenues are available to all wings of the service which is included in the cadre which is included in this service. Now, my lord, I'll press into service only one point, my lord. I did not trouble your lordships with anything else. Now, in view of the past practice and my lord certain legal position, we have a vested right. Now, whether my vested right can be taken away. Now, my lord, it's a different matter. Yes, after the framing of the rules, if somebody enters service, yes, in that case, you can apply the rules and whosoever enters henceforth, their cases will be considered accordingly because abolition and creation of post is the prerogative of the executive. How you would like to, frame a rule because administrative exigencies are best known to the authority. But ours is a case where our vested right is sought to be taken away. That, my lord, in view of the 2-3 judgments of the Honorable Supreme Court, my lord, it cannot be taken away. Now, since my case hinges only on that point, my lord, may I place those cases? First, I will refer to my lord, 1987 PSCC 622. Ishan, huh? 1987 3 SCC 622. এখন ওলাই যাব পারে। আগে এখন। Lords will kindly come to para 16 at page 636. This memorandum dated December 7, 61 was considered in Balesar Das case by this court, and it was held that this government order was not arbitrary insofar as it fixes the proportion of permanent vacancies to be filled up from various sources, and it has statutory force being under Rule 6. It has also been observed that the office memorandum makes it clear that direct recruits will be made to both permanent and temporary vacancies of the assistant engineer. But this scheme of 1961 cannot stand in isolation and has to be read as subordinate to the rules of 1936. After all, the 1961 memorandum cannot override the rules which are valid under Article 313 and so must be treated as filling up the gaps, not flouting the provision. Hence, the said OM does not affect the petitioners who have become members of the service and are entitled to have their seniority reckoned from the date of their being members of the service according to Rule 23 of the 1936 rule. 1969 rules and 71 rules have, however, affected the rights of the respondents who have become member of serving, being substantively appointed in temporary post as assistant engineer, inasmuch as there has been an amendment affected in Rule 3B by providing that a member of the service meant a government servant appointed in a substantive capacity to a post in the cadre of the service. Rule 3 also amends the earlier provision by meaning direct recruit as in the manner prescribed in Rule 5A1 and 5B1. Similar amendments have been made in Rule 5 and 6. The effect of this amendment is that assistant engineers who have become members of service being appointed substantively in temporary post will no longer be members of this service and will have to wait till they are selected and appointed as assistant engineer on Rule 5A2 against the quota fixed by Rule 6 for this purpose. This creates serious prejudice to them, and it also creates uncertainty as to when they will be selected and appointed against the quota set up for selection under Rule 5A2. The amended Rule 23 lays down that a seniority will be determined from the date of the order of appointment in substantive capacity. This amended rule lays down that seniority will be determined from March 162 to the existing officers, that is, respondents appointed substantively against temporary vacancies. It has been urged that government has the power to amend rule retrospectively, and such rules are quite valid. Several decisions have been cited of this court at the bar. Undoubtedly, government has got the power under proviso to Article 309 to make rules and amend the rules giving retrospective effect. Nevertheless, such retrospective amendment cannot take away the vested rights, and the amendment must be reasonable, not arbitrary or discriminatory, violating Article 14 and 16. Where on this, my lord? There is no bar to make even retrospective amendments, but in the process, we cannot take away the vested right. In case of T.R. Kapoor versus State of Haryana, this court observed, it is well settled that the power to frame rules to regulate the condition of service under proviso to Article 309 of the Constitution carries with it power to amend or alter rules with retrospective effect. It is equally well settled that any rule which affects the right of a person to be considered for promotion is a condition of service, although mere chance of promotion may not be. It may further be stated that an authority competent to lay down qualification for promotion is also competent to change the qualification. The rules defining qualification and suitability for promotion are conditions of service, and they can be changed retrospectively. This rule is, however, subject to a well-recognized principle that benefits acquired under the existing rules cannot be taken away by an amendment with retrospective effect. That is to say, there is no power to make rules, such a rule under the proviso to Article 309, which affects or impairs vested right. Therefore, unless it is specifically provided in the rules, the employee who are already promoted before amendment of the rules cannot be reverted and their promotion cannot be recalled. In other words, such rules having laid down qualification for promotion made with retrospective effect necessarily must satisfy the test of Article 14 and 16(1). It has been held by this court in Ruepa versus so-and-so that there should not be arbitrariness in state action, and state action must ensure fairness and equality of treatment. It is open to judicial review where any rule or provision of any act has violated the principles of equality and non-arbitrariness and thereby invaded the rights of the citizens guaranteed under 14 and 16 of the Constitution. As has been stated herein before, assistant engineers who have already become members of service on being appointed substantively against temporary posts have already acquired the benefit of 1936 rules for having their seniority computed from the date of their becoming members of the service. The 69 and 71 amended rule takes away this right of these temporary assistant engineers by expressly providing that those assistant engineers who are selected and appointed in a permanent vacancies against 50% quota, provided Rule 6 of the amended 1969 rules, would only be considered for the purpose of computation of seniority from the date of their appointment against permanent vacancies. Therefore, the temporary assistant engineers are not only deprived of the right that accrued to them in the matter of determination of the seniority, but they're driven to a very peculiar position in as much as they have to wait until they're selected and appointed against the permanent vacancies in quota set up for this purpose by this so-and-so. The direct recruits on the, anyway, my lord, these are the facts. So question is, you can amend the rules, but you cannot take away any vested right. Now to this, for this proposition, I am relying on one more decision, my lord. That Tushar Ranjan Mohanty's case, 1994, 5 SCC 450. My lords will kindly come to para 12 at page 456. In T.R. Kapoor versus State of Haryana, three petitioners, T.R. Kapoor, Mahinder Singh, and V.D. Grover, where diploma holders were working as subdivisional officers on regular basis under unamended Rule 6B of the Punjab Service Engineers Class 1, Public Works Department Irrigation Branch Rule 64. They were eligible for promotion as executive engineer in Class 1 service, despite the fact that they did not possess a degree in engineering. By the notification dated 22nd of June 84, Rule 6B was amended and it was provided that a degree in engineering was an essential qualification for promotion of assistant engineer, irrigation branch to Class 1 service, and thereby the petitioners were rendered ineligible for promotion to the post of the executive engineer in Class 1 service. The amendment was challenged in this court by a petition under Article 32 of the Constitution of India. This court came to the conclusion that retrospective effect given to the amendment was violative of Article 14 and 16 of India on the following reasoning. It is well settled that power to frame rules to regulate the condition of service under proviso to Article 309 of the Constitution carries with it the power to amend or alter rules with retrospective effect. It is equally well settled that any rule which affects the right of a person to be considered for promotion is a condition of service, although mere chances of promotion may not be there. It may further be stated that an authority competent to lay down qualification for promotion is also competent to change the qualification. The rules defining qualification and suitability for promotion are conditions of service and they can be changed retrospectively. This rule is, however, subject to the well-recognized principle that benefits acquired under the existing rules cannot be taken away by amendment with retrospective effect. That is to say, there is no power to make such a rule under proviso to Article 309 of the Constitution of India. Finally, this court considered the effect of retrospective legislation on vested right of affected persons in PD Agarwal, the judgment where I referred, my lord, the assistant engineer substantively appointed against temporary vacancies became member of service were entitled to seniority on the basis of continuous length of service. The rules were amended in the year 6971, wherein it was provided that assistant engineer will only become members when they are selected and appointed against quota meant for them, and the seniority will be determined only from the date of their appointment in substantive vacancies. These amendments were made with retrospective effect, thereby taking away the vested right of the assistant engineers appointed against temporary posts. And this paragraph I have already placed in the PDF judgment. Therefore, my lord, my humble submission is the sort of an, my lord, the vested right which is sought to be taken away. This is, in my humble submission, is not permissible, my lord. Last judgment, my lord, that well-quoted judgment, that's a constitution bench judgment in my lord special court bills on Article 14. That's 1971, 9, 1 SCC 380. I'll rely upon my lord paragraph 72, subparagraph 4, 6, and 8. The lords will kindly come to page 424. That's subpara 4 of para 72. Of course, the para 72, lordship will find at 423.
Page.
The relevant page is 380, my lord. And the operative portions are at 424 and 425. 79 1 SCC.
Para 72, na?
Yes, my lord. 72. No, sorry, my lord. Para 72. Yes, yes. Subpara 4.
Para 4.
Yes, at page 424. The principle underlying the guarantee of Article 14.
Yes.
The principle underlying the guarantee of Article 14 is not that the same rules of law should be applicable to all persons within Indian territory, or that same remedies should be made available to them irrespective of differences of circumstances. It only means that all persons similarly circumscribed shall be treated alike, both in privileges conferred and liabilities imposed. Equal laws would have to be applied to all in the same situation, and there should be no discrimination between one person and another if, as regards the subject matter of the legislation, their position is substantially same. Then my lords will kindly come to subparagraph 6. The law can make and set apart classes according to the needs and exigencies of the society and as suggested by experience. It can recognize even degree of evil, but classification should never be arbitrary, artificial, or evasive. Then please come to 8. The differentia, which is the basis of classification, and the object of the act are distinct things, and what is necessary is that there must be a nexus between them. In short, while Article 14 forbids class discrimination by conferring privileges or imposing liabilities upon persons arbitrarily selected out of a large number of other persons similarly situated in relation to the privileges sought to be conferred or liabilities proposed to be imposed, it does not forbid classification for the purpose of legislation, provided such classification is not arbitrary in the sense above mentioned. So these are the broad principles, my lord. Now coming to the facts of this case, my lord, ever since the directorate is functioning, my lord, at least from the year 1990, though it was amended in 1998, until 2016, my lord, that was the position. So by virtue of that, we have a legitimate expectation, at least I have a right to be considered for promotion, which is again a fundamental right. Now, if that is to be taken away, you can take it away by a procedure, fair procedure. Now, by taking away vested right can't be construed as a fair procedure, my lord. So therefore, my lord, in substance, our argument is this rule, it can operate prospectively. Henceforth, if the appointments are made, they can be covered by this. But the persons who are already in service, who have a vested right to be considered for promotion to the grade of director in terms of the earlier rule, that cannot be tinkered with. That is my case, ma'am. And I reserve my right of reply subject. Unnecessarily, I'll be, multiplying the things, my lord. Basically, this is our case.
May it please, Lordship. My lord,
Yes,
the grievance is very simple. Grievance is that the engineers, they reach only up to the level of superintending engineer. And there is only one post of director. It's a director of town and country planning. For the post of director, the feeder cadre is the joint director in the planning wing. Planning wing. Admittedly, there are three wings, madam. My lord, before I justify as to why only the planner, a planner is given the opportunity of reaching the top and not the engineers. For that, I would like to refer to the Act of Town and Country Planning Act itself first.
2016.
Minor.
Yeah.
1959, madam. 16, there are three rules. The challenge is to the rules.
Okay.
Yes.
1959.
Yes, I'd like to draw your lordship's attention to the Act of 1959, madam. Madam, what I would like to project before lordship is, it is a department, it is a directorate of town and country planning. The primacy should be with the planner. Planners are having a greater responsibility, and planners should have the primacy because ultimately the responsibility.
This greater responsibility you realize in the year 2016 only, or?
No, rules came for the first time in 2016 only, my lord.
So
Earlier there were no rules.
1959, this practice was going on that
Yes.
all the three branches.
Yes.
Members of all the three branches were entitled for the promotion on the post of director.
No, my lord, but earlier there is a judgment which they have annexed in the reflection. There also the superintendent engineer sought a direction that he should be equated, should be treated to be at par for the purpose of promotion to the post of director. That was not accepted. It's a part of the reflection. I'll come to that. There is a judgment of this on court. My lord, what I want to show from the act is, my lord, from the preamble itself. Town and Country Planning Act 1959.
Town and Country Planning Act 19.
Northeast statute below is Tatu. Volume 2, 7, 8 and go. Teams of T.
Just a minute.
Map.
Yeah.
That's all. May I proceed? Your Lordship, with up to budget. At 49. Keeps up town and country. I read very slowly when till the time they find
You've
out.
not given the list of books.
I've given the list of books, but the this book I have not, journals I've given SCC.
It's there in Vikke Diwan, I think, volume
Yes,
17 or 18.
because it is there in the statute book itself, man. We have got VK1 subsequently another my lord series.
You proceed.
My lord, I'll just read slowly this preamble part. It's a small paragraph on it. An act, Assam Town and Country Planning Act 1951, an act to provide for the development of the towns and countrysides of the state of Assam. Preamble. Whereas it is expedient to provide for the development of the towns and the countrysides of the state of Assam on sound planning principles. Sound planning principles with the object of securing proper sanitary conditions to conserve and promote the public health, safety, and general welfare of the people living therein. It is hereby enacted. So my submission to your lordship is, the act itself says, my lord, these rules are framed for the regulation of the service conditions of the employees of the Directorate of Assam Town and Country Planning, and there are three wings: engineering, research, and planning. Now, the act itself says, my lord, the job of the directorate is to develop the town and country on sound planning principles. Planning is the main requirement of the directorate, my lord. They will work in tandem with the engineers and the researchers. Engineers and researchers will assist the planners, but ultimate responsibility lies with the planners. It is the responsibility of the planners which will ultimately, my lord, subserve the cause and the purpose for which the act is enacted. Even in the provisions, my lord, section 9 of the act, 9 of the act says, section 9 of the act, my lord. Okay. And I'll read two provisions of the Act slowly, section 9 and section 11. Library. Section 9, my lord, is under the caption Preparation for Master Plan.
All right.
I'm sorry, but I was under the impression that these acts, local acts of It is there in the Divan's, my lord, series of statutes of the state, my lord.
These provisions in your reply or somewhere else?
So so Mr. Majumdar, we understand what your projection is, that may be valid.
My lord.
Here, there is only one thing.
My lord.
The law is settled that earlier there was no act,
My
it
lord.
was an executive instruction. So the rules came only in 2016,
My lord.
which has a force of a statute.
My lord.
The only question is, does it take away any right accrued upon the
I
petitioner?
understand. That
That's
will
the only
be my,
point.
yes, my lord. That will be my
So
second
Mr.
reply.
Chaudhary is not here, we'll ask him.
My lord.
In T.R. Kapoor's case, that was a case where subsequently by amendment of the rules,
Yes.
there was an attempt to revert those people who were promoted on the basis of the earlier qualification prescribed by the rules.
My lord, yeah.
So only thing we have to see is that does it take away any right which is vested?
My lord.
So the point here is,
My lord.
if only merely because the petitioner was otherwise entitled to be considered for promotion
My lord.
under the executive instruction,
My lord.
by notifying the rules framed under 309, Article 309 proviso, does it take away any vested right? If not, we will not interfere. If
Right.
yes, that's the short point here, nothing
Absolutely, my lord.
else.
To that, my lord, let me
Can
reply
you
to your
address the
lordship.
court on that
Absolutely,
only?
my lord. I'll be.
We are not on
I
what
will-
is the object, what is the
I will
rationale?
answer to these both these points. My lord, my submissions will be twofold. First of all, the under 309, this judgment 94 judgment which my learned friend has relied itself says that under 309 state can vary the existing rules.
Right.
Number one. Number two, which is most important here is, my lord, taking away vested right is one thing, and making a new rules which changes the rules is another thing. Here, it is not the case of the petitioner. It is the association which has come. It is not the case of the petitioner that as an employee of the department, I was holding a particular post on the date when the new rules came into force. I was eligible, and you are taking away my right to be considered for promotion. This is one thing, my lord, to say that as a rule has been framed whereby now the department will not consider the case of a superintending engineer for the post of director. This is one thing to say that, and it is another thing to say that on the date these rules have come into force, a person was already eligible. Only after maybe 2, 3, 4 years, 4 or 5 years of time, he will acquire the eligibility criteria, and then he will be promoted. And by virtue of this new amendment or the introduction of new
Reducing the
rules,
prospect of promotion.
yes, yes. What I am trying to submit before Lordship is, my lord, is not the case of the petitioner that I have already acquired the eligibility under the existing rules. Now, by an amendment, you are taking away my right, which I have already acquired. It is not their case. They are changing the rules as a whole. What they want is, in future, as and when you make a promotion, you should consider case of a researcher, not researcher, engineer, also for the post of director. But the government has now taken a call, made a rules under in exercise of power under proviso to Article 309, and for the all time to come in future will not allow a person holding the post of superintending engineer in the engineering wing to be eligible for the post of director. It is a completely different thing. It's not the case of taking away one's right. And for that, I'll be relying on one judgment which says that government has the power to alter and vary.
So what is the qualification of a director planning?
His planning, my lord,
Yes.
his initial level qualification itself, he should be having a PG, postgraduate diploma or degree in planning from a recognized.
Is it provided under the
Yes,
rules?
my lord.
Where is it?
Yes. Lordship may kindly turn to the rules, my lord. Page 104, it starts, my lord, planner's rules. Yes. Page 111, my lord. 111. Assistant director is the entry level, my lord. Page 111 at the bottom, my lord, under schedule 3. Academic qualifications prescribed for direct recruitment to the cadre of assistant director. 1. A candidate for direct recruitment to the cadre of assistant director must possess postgraduate degree or diploma in town and country planning, city or regional planning from any recognized institution or its equivalent qualification. So my second leg of argument will be the qualification prescribed is different for the planners. An engineer doesn't have a qualification of planner, whereas a planner, in addition to his engineering degree, must have this degree so as to be eligible for the post of assistant director under the planning service rules. My lord, lordship may kindly refer to 2-3 paragraphs of my additional affidavit that we have filed, and which your lordship will find, my lord, from page 120 onwards. And page 129, in just small 3 paragraphs, my lord, we have highlighted the reasons on which we would like to justify the routes, my lord. Page 129, my lord. Yes, page 129, paragraph 3, my lord. My lord, I'm reading from paragraph 3, your lordship may kindly permit me from top, my lord. That the deponent begs to state that the main function of the Directorate of Town and Country Planning is to prepare the master plan for all the towns of Assam under the provisions of Assam Town and Country Planning Act 19.
Which para you are referring to?
Para 2 at page 129, my lord, on top, my lord.
That with regard to the statement in paragraph,
My lord, page 129, para 2.
must be some
problem with the pagination.
chevron in pagination.
It is the affidavit filed by Mr. R. Ahmed.
My lord, my lord. Second page, para 2, my lord. If your lordship has got the affidavit that we have filed on 28th of February, my lord.
Para number 2.
Richand Ahmed, right?
My lord, my lord, my lord.
Right.
Richard Ahmed.
Para 2 is something else.
That I'm working as a joint secretary of
My
government.
lord, there are 2 affidavits. Earlier we filed the affidavit of opposition. This is additional affidavit filed on 28th of February 2024, my lord. Recently, madam.
Then that is pagination 176. Page 176.
And if the affidavit is there, may I read my para 2? I'm sorry, my lord.
Please correct it. It's page 176.
176. Yeah.
I'm sorry. I'll just correct. Then para 2 I'm reading, my lord.
Yes, yeah.
That the deponent begs to state that the main function of the Directorate of Town and Country Planning is to prepare the master plan for all the towns of Assam under the provisions of the Assam Town and Country Planning Act 1959, and also to carry out various works related to urban realm area of the state, including the implementation of the urban reform agenda prescribed from time to time by the state government and the government of India. In order to achieve the above objectives, 3 distinct wings have been created in the Directorate of Town and Country Planning, and these are as follows. Town Planning Wing, consisting of town planners; Engineering Wing, consisting of civil engineers; Research Wing, consisting of persons with research background. That it is paragraph 3, my lord, that it is stated that the master plan for towns are prepared and implemented by the town planners who take the lead role and are qualified and trained to do so. The essential qualification of town planners is postgraduate degree in town and country planning, urban planning from a recognized university, over and above their bachelor's degree in civil engineering, architecture, or master's degree in geography or economics. The other 2 wings, namely engineering wing and research wing, are supportive in nature. The role of civil engineers is to plan and implement projects as guided in the master plan, while the persons from research wing contribute to the job of analysis of data and information that are required for the preparation of master plan. The deponent states that keeping in view these distinct nature of works and responsibilities, the government of Assam has notified 3 service rules as follows to govern their service matters, which are as follows. Assam Town and Country Planner Service Rules 2016. Then next is Assam Town and Country Planning Engineering Service Rules 2016. And lastly, Assam Town and Country Planning Research Service Rules 2016. That the hierarchy in the cadre of town planners and engineers are as shown below. Town planner, director, joint director, deputy director, assistant director, engineer, superintending engineer, executive engineer, extended engineer. As per Assam Town and Country Planning Town Planners Service Rules 2016, the feeder post to the post of director is joint director and not the superintending engineer. Though the two posts, namely the post of joint director and the superintending engineer, are equivalent in rank, but there are functional differences for which their cadres are distinct and separate, which have been reflected and in service rules notified by the government. That all the incumbent in the town planning cadre have its essential qualification of postgraduate degree in town and country planning, urban planning from a recognized university over and above the bachelor degree in civil engineering, architecture, or master degrees in geography and economics. By the time an incumbent becomes eligible for promotion to joint director, he gathers 25 to 30 years of experience in preparation and implementation of master plan for town and also in the urban areas. On the other hand, the essential qualification for engineers in engineering wing is bachelor's degree in civil engineers. A superintending engineer, when promoted from executive engineer, is equipped with the skill in preparation and management of civil engineering projects and estimate, including their implementation, and not in preparation of master plans of the town. That the deponent respectfully states that the post of director, being the head of the Assam Town and Country Planning Directorate, requires sufficient knowledge and skills regarding preparation and implementation of master plans, and also in addressing various issues relating to urban affairs. Therefore, the post of joint director has been made the feeder post for promotion to the post of director, and accordingly provision have been made in the Assam Town and Country Planning Town Planners Service Rules 2016. And this is how we would like to justify. And matter, if your lordship has got the book, I'll rely on two more provisions of the act. Lordship may kindly turn to page 16 in this book, section 9 of the act.
But Mr. Mozumdar, what is the point in getting so deep into justification of doing this? We are not examining the justification. You are addressing the court on the justification.
I'm just
That's
trying.
not the point
No,
here.
these provisions I'm referring to for the purpose of my lord arguing that it is the planners who are getting primacy in the directorate.
Maybe it is open for the government to decide.
My lord,
Only point here is, does this rule take away or abridges any right,
my lord.
which is
Then-
already
then I'll-
crystallized?
Then I'll
That's the
confine my
only point
argument to
here.
that one. Yes, yes.
According to him, the executive instruction had conferred. It's all about elimination of the
They have also not challenged that they can't make such rules. Their argument was only this, that they vested right has been taken away. That's all.
Then I'll restrict my argument only to the point as to whether there is a question of taking away their existing or vested right, number one, and number two, whether we have power to make the rules.
That is, they are not challenging.
My lord,
They are referring thus. They have power even with the retrospective effect,
my lord,
but vested right.
vested right. My lord, my submission will be, here is a case where there is no question of any vested right.
That's only you
My
to
lord,
satisfy
my lord,
us on this
my
point, and that's
my
all.
lord. My lord, I say there is no vested right because the petitioner, your lordship has seen, is an association. Association has come to challenge the rule as a whole to say that the engineers should be given the opportunity of rising to the top, that is the post of director. That is the case. It is not the case of the petitioner that they have got a vested right under
This is the only case, sir. What they argued, you also heard it, that the engineers have vested right. And by this 2016 rules, they have taken away that vested right. This is what, whether they're vested right or not.
My lord,
That's another.
my lord, that's what I'm saying, my lord. They do not, if the rules are where 1990 orders were there, subsequently when we have framed the rules, now by framing the rules, if the post of superintending engineer in the engineering wing has not been made the feeder cadre for the post of director, there is no question of taking away any vested right. This is my submission. And for that, I'll be relying on 2-3 judgments. The Lord will kindly permit me to refer to 2 judgments. Oh. First, I'm relying on the judgment of my reported in 2003, volume 2, SSC, page 632. Page 632, P.U. Joshi versus Accountant General Ahmed. This is 2003, volume 2, SSC, page 632. And I'm referring to para 10 at page 639. Para 10 at page 639. Lordship is going to para 10. We have carefully considered the submissions made on behalf of both the parties. Questions relating to the constitution, pattern, nomenclature of posts, cadres, categories, their creation, abolition, prescription of qualifications and other conditions of service, including avenues of promotion and criteria to be fulfilled for such promotion pertain to the field of policy is within the exclusive discretion and jurisdiction of the state, subject, of course, to the limitations or restrictions envisaged in the Constitution of India, and it is not for the statutory tribunals, at any rate, to direct the government to have a particular method of recruitment or eligibility criteria or avenues of promotion, or impose itself by substituting its views for that of the state. Similarly, it is well open and within the competency of the state to change the rules relating to a service and alter or amend and vary by addition, subtraction, the qualifications, eligibility criteria, and other conditions of service, including avenues of promotion from time to time, as the administrative agency may need or exercise. Likewise, the state by appropriate rules is entitled to amalgamate departments, or well, this is we are not concerned. So what I'm trying to emphasize, my lord, is that even the avenues of promotion can be laid down afresh with a new structure. So here what
You have left out the most important part.
my lord. Let me read the remaining part. Likewise, the state by appropriate rules is entitled to amalgamate departments or bifurcate departments into more or constitute different categories of posts or cadres by undertaking further classification, bifurcation, or amalgamation, as well as reconstitute and restructure the pattern and cadres, categories of service, as may be required from time to time by abolishing the existing cadre posts and creating new cadres and posts. There is no right in any employee of the state to claim that rules governing conditions of service should be forever the same as the one when he entered service for all purposes and except for ensuring or safeguarding rights or benefits already earned, acquired, or accrued at a particular point of time. A government servant has no right to challenge the authority of the state to amend, alter, and bring into force new rules relating to even an existing service. This paragraph squarely covers my submissions.
But you have not read it.
I'm sorry, I'm extremely sorry, man. My lord, here, as I submitted, I'm repeating when my learned friend was not there. What I'm submitting is, it is not the case of it's a case by association as a whole. They are challenging the rule as a whole without indicating, and in fact, it's not a case by an individual to say that I have acquired a right under the existing rules and I was about to be promoted by introducing a new rules or by amending the rules. You are taking away my accrued right. And here the Supreme Court says I can change the avenues of promotion. And we have changed the avenues of promotion so far as the engineering wing is concerned, my lord. By changing the avenue of promotion, we have said that it is the feeder cadre will be from the planning wing.
Yes.
Two more judgments may help.
Yeah, sure.
Next, 2003, volume 6 SSC, 535. There are 16 and 17. 2003 6 SSC 535, page 542, there are 16 and 17.
Yes.
There are 16. Fixation of quotas or different avenues and ladders for promotion in favor of various categories of posts in feeder cadres based upon the structure and pattern of the department is a prerogative of the employer, mainly pertaining to the policy making field. This is I am emphasizing. The relevant considerations in fixing a particular quota for a particular post are various, such as the cadre strength in the feeder quota, suitability more or less of the holders in the feeder post, their nature of duties, experience, and the channels of promotion available to the holders of post in the feeder cadre. Most important of them all is the requirement of the promoting authority for manning the post on promotion with suitable candidates. Thus, fixation of quota for various categories of posts in the feeder cadre requires consideration and various relevant factors. A few amongst them have been mentioned or for illustration. Mere cadre strength of a particular post in the feeder cadre cannot be a sole criterion or basis to claim parity in the chances of promotion by various holders of post in feeder category. Para 17, normally, where officers are to be drawn for promotion from different posts in the feeder cadre, quota for each post in the feeder cadre is maintained proportionately to the sanctioned strength in that post. This, however, cannot be an inviolable rule of strict application in every case, with an absolute quality of arithmetical exactitude, but may vary from case to case depending upon the pattern, structure, hierarchies in the departmental setup, as well as exigencies and balancing needs of administration. There are other relevant considerations, some of which have been mentioned above, which may require departure from the practice of fixation of quota for each post in the feeder cadre, solely proportionate to its strength. And my lord, some more submissions, my lord. One is, my lord, in 1991 itself, my lord, in that Council of Scientific Research, the Honorable Supreme Court said, every employee after he is employed, he must have career advancement. There should be opportunity for advancement. It is not the case here that a person after appointment, he has got no avenue of promotion. He has, even in the engineering wing, up to the level of superintendent engineer, he has that. So that principle will not help them. And thirdly, my lord, right to be considered promotion, to be considered for promotion is a fundamental right. But here, it is not a case that a person is eligible and he has not been considered for the post, and therefore his right is fundamental right has been violated. It is not their case. Under the rules itself, you are not entitled. So there is no question of violation of any fundamental right for not being considered for promotion to the post of director. So there being the position, my lord. And my lord, your lordship is aware, my lord, I can cite one judgment also, that there is always a presumption in favor of validity of a legislation, also the rules. This is a statutory rule framed under the Constitution. And it is for the petitioner to show that there has been a violation of, there are two ways in which a validity of a rule can be challenged. One is competence, and the other is a violative of the part 3 of the provisions of the Constitution or any part of the provisions of the Constitution. Yes. And for this matter, I'm relying on 1989 4 SSC page 179. Okay. Validity in favor of page 89 4 SSC, page 179. And these rules framed under the proviso to Article 309 is also a delegated legislation, but it is delegated by the Constitution itself.
Which para you are referring to?
My lord, para 97 says, my lord, if para 97, I'm relying on para 97, 99, 100 and 101.
Page
238 and 239. Para 97, my lord. May I read, my lord? Page 239, 238. Para 97. Para 97.
Judgment citation title.
89 4 SSC, page 179.
Title of who are the parties?
Messrs. Cardamom Planters Association.
So 88, 89 is not the para, it ends with para 15. Is 88, 89 in Supreme Court Employees Welfare Association, 89 4 SCC 187.
I'm citing this 1989 4 SCC 179.
179 is judgment in this Cardamom Planters Association.
My lord.
It ends with para number 15, sir, at page 186.
I'm extremely sorry for
It traveled to some other place.
That 1989 4 SCC 187.
I'm sorry, man. Flag is somewhere else, man. This is 1989
going by the flag,
page,
not by
it
the
starts from page 187, man. Same book, man. I'm sorry, man. Supreme Court Employees Welfare Association.
Yes, para number 98.
97, man.
97.
Now, I'm relying on para 97, 99, 100 and 101.
Read.
97 I'm reading, madam. The fact that the power, Lordship has got, madam. Para 97.
Yeah.
The fact that the power exercised by the Chief Justice of India or the President under Article 146 is derived directly from the Constitution and not from a statute makes no difference to the power of judicial review by a competent court.
Right.
Any action taken or refusal to act on the strength of power derived directly by constitutional delegation is as much justiciable or reviewable upon the same grounds and to the same extent as in the case of any statutory instrument. The fundamental question in determining whether the exercise of power by an authority is subject to judicial review is not whether the source or his power is the constitution or the statute, but whether the subject matter under challenge is susceptible to judicial review. Pure questions of facts and questions which cannot be decided without recourse to elaborate evidence or matters which are generally regarded as not justiciable, such as, for example, those relating to the conduct of external affairs or the department. We are not concerned with this. I just first three few lines. Then also may kindly turn to para 99. There is indeed a higher degree of presumption of constitutionality in favor of subordinate legislation than in respect of administrative orders. This is especially the case where rules are made by virtue of constitutional conferment of power. Rules made directly under the Constitution may have, in a certain sense, greater legislative efficacy than rules made under a statute within the field demarcated by the Constitution. The former can, if so provided, operate retrospectively. These rules are, of course, as in the case of all statutory instruments, controlled by the Constitution and the laws. Para 100. Where the validity of a subordinate legislation, whether made directly under the Constitution or a statute, is in question, the court has to consider the nature, objects, and scheme of the instrument as a whole. And on the basis of that examination, it has to consider whether what exactly was the area over which and the purpose for which power has been delegated by the governing law. And pen 101 minute para. Rules are liable to be declared invalid if they are manifestly unjust or oppressive or outrageous or directed to an unauthorized end or violative of the general principles of law of the land, or so vague that it cannot be predicted with certainty as to what is prohibited by them, or so unreasonable that they cannot be attributed to the power delegated or otherwise disclose bad faith. This much only. That's all.
May it please the Lordship. Mr. Chaudhary, before you begin, just for a clarification, it is not your case that these rules are discriminatory in nature and is contrary to Article 16. That's not your case.
Not. That's why I said, my lord, henceforth, if somebody enters service after 2016, that rule will very much apply. And my lord, the aspect of the government that planners have to give in a role of primacy, that they may be right, my lord. As an employer, that is their prerogative, and that is their preserve to find out and give primacy as they may consider. Over that, lordship will not sit in appeal over in judicial review. Now, we are on a very narrow campus, my lord. Now, lordship will kindly see the division bench judgment, which my learned friend has not addressed to lordship. That's the most vital part. The division bench judgment recognizes the post of superintending engineer as the feeder post for the promotion to the post of director. Now, is it a validating legislation by which they want to take away the basis of the judgment? No. Yes, had the rules been a validating legislation, yes, they could have. It is not their case that we have taken away the basis of the judgment in DB.
No, but then it was the executive instruction which did provide so.
No, my lord, there is a judgment. The judgment recognized the right of a superintending engineer to be in the feeder cadre for promotion to the grade of the director.
But that judgment deals only with the executive orders.
What I'm saying is, be it, my lord, even that executive, there are judgment of the Supreme Court, my lord, in absence of Article 309 rules, even executive orders are also enforceable.
Yeah, no doubt.
Now, my lord, no, what I'm trying to submit, though that may not be very relevant, but what I find, my lord, subject to your lordship's kind consideration, that judgment recognizes the right of the engineering branch to be, or the superintending engineer to be in the feeder cadre. Now, there is a basis of the, that basis of the judgment could have been taken away by appropriate rules. But in which case, that rule has to be an validating legislation, which it is not. Number one.
Certainly, when there was a provision, then the court has ruled that superintending engineer post is equivalent to the joint director.
Yes.
As it is an integrated post or something integrated. But now, as you yourself have said, that the state government, the government has power to change the rules, qualification of the promotions.
Yes.
But can't take away the vested
right.
Where is your vested right here?
My vested right.
When this right was accrued to you.
Because of
it was in the future, was supposed to accrue.
No, my lord. No, my lord. Question is not that. Then, my lord, what meaning we give to that 2003, that order of 1990? That governed my condition of service.
But now with the 2016, they have...
Very well. Very well. You can do that. That we are not disputing. Question is, you apply that to people who enters the department after 2016. What will happen to the right of the people who are already in service? The two judgments I have referred, it deals with the right of those people, my lord.
But in one of the judgment, this the earlier the employee was promoted to a post and after this.
It was sought to be
you
brought
know,
down,
They were reverted.
reverted.
So
And
there was an accrued right to them.
no, my lord, the issue is, be it a question of holding a promotional post or be it claiming seniority, these are all condition of service. Now, in the later case, what had happened, they were appointed to some temporary post. But by virtue of the earlier rule, they were entitled to seniority. But by the amendment, unless they were recruited in terms of Rule 6, then they will not get seniority. Supreme Court says, no, you can't do this. Same principle will apply here, my lord. Our simple case is, this is the past practice. Otherwise, it is consistent with the 2016 rules, other than to bifurcate the services.
Mr. Chaudhary, one clarificatory query. You see, you have already said discrimination is not your argument.
Yes.
So we keep it aside.
No,
Your argument is.
no, let me paraphrase it, my lord. When I say discrimination is not my argument, what I want to convey is, qua, my lord, my subsisting right.
No, we have understood.
Yes.
No, see, that's fine. Now, you are urging this point of vested right or accrued right being taken away on the premise that under the executive order of 1990, the engineering wing also had an avenue of promotion up to the rank of director. But with the advent of the new rules, 2016 rules, that avenue has been cut short at the level of superintendent engineer. So what basically you are urging is that the avenue of promotion of members belonging to your association, which was earlier up to the rank of director, has now been restricted up to the rank of superintendent engineer. That's your argument.
That's
Where is the question of vested right here? What was the right? It was an opportunity available, which is now gone with the rules. It's not a question of vested right. That's what we are putting it to you. Please address us.
No, I'll address. My lord, when we say vested right, necessarily it did not follow from a rule or a statute. Even past practice also can lead to a vested right, my lord. That's the judgment in that which is case to case. My lord, there are judgments on this point, my lord. What is the meaning of vested right? There is a judgment of the Supreme Court, my lord. If there is a past practice in a department, then, my lord, that is a vested right. That also leads to a vested right.
Past practice in accordance with some rules.
My lord,
or the order.
it's not that past practice
But
is.
here now, if they change that rules or introduce some new rules.
No, that new rule has tinkered with my earlier right. Kindly see, my lord. My lord, my learned friend has referred. Let me give one example, my lord.
Yes.
Supposing, let us take the example of a case where rules are there. So the condition of service is governed by a rule. Rules are framed. Now, when it comes to earning the promotional avenue, supposing new qualifications are prescribed, then Supreme Court says, yes, this is permissible. Based on higher qualification.
No, that's right. Just for a moment. You see, the matter could have been a little different if a particular individual who was serving as a superintendent engineer on the date on which the rules were introduced comes to the court saying that today, when the rules are introduced, before that, I was eligible for consideration.
In fact, the president of the association, he was superintending engineer, he was the in-charge director. After the rules came, somebody else has been appointed.
Therefore, individual rights, it's a matter of.
No, my lord, let us not go to that aspect. At least at the stage of hearing, lordships will not bring that. My learned friend is, I can appreciate as a lawyer, he's saying that. No, it's not a question of locus. It's not a question of lack of locus.
It's not a question of locus.
It's not a private interest.
Mr. Chaudhary, this This deliberation is only try to understand the facets.
My lord,
It's not a question of locus.
petitioner association is a registered association. Therefore, the welfare of the members of the association, for protecting the rights of the members of the association, they can maintain a writ petition. They're a registered
The
association.
question is not of maintainability. We're not on maintainability. This court cannot visualize and speculate what is the effect of these rules with regard to all members of the association. If it was an individual coming in, then we could have seen on that particular day what was his entitlement, was there any right vested, and answer the query raised.
So
But
petitioner,
if an association comes,
petitioner number
it is
two-
essentially a question of
petitioner number two
discrimination.
is a member of the, he's also an officer. The petitioner number 2 is an officer. The petitioner number 2 is very much there. And these days, lordship will not suit me on the ground that association is before a lordship. Petitioner number 2 is very much an, officer of the engineering wing. Husband কি আছিলে past practice তোমালোকৰ একো মনতে নাথাকে 1993 নে 2003 supplementary Lord, there are, today I'm not ready with that, two judgments, my lord. One judgment, Supreme Court has clearly said what is the meaning of vested right. Secondly, past practice. And third, most importantly, my lord, even service orders are, my lord, akin to, rules, where it has been elevated.
In the absence of rules, certainly.
Yes, there were no rules. So for the first time, they have come up with the rules in 2016. So those judgments will be relevant. I didn't expect that question to fall, my lord. In fact, my lord, when the proceedings were going on, they filed an affidavit and said that we are coming with the rules. When the proceedings were going on, the affidavit filed.
Which proceedings?
This proceeding, my lord.
So they're going,
That they are going to frame rules. They might take care of our grievances. In fact, my lord, lot of negotiations also took place. Eventually, it failed. In fact, for almost
Now-
1 or 2 years.
Now it seems that the stand is very clear.
Yes.
They are not going to face it.
No, my lord, prospectively regarding, my lord, that after 2016, that would be the position that we are not laying a challenge to that. Our question is, because of the service order, whether our right will evaporate. That's the only point to be decided. Whether in view of the two judgments I have cited, it can be said that I do not have a vested right. 2010,
Yes.
6 SCC. My lord, the lordship will kindly give me one more opportunity, my lord. I'd like to bring 3 judgments before lordship.
You supply the copy. Judgments. You supply the copy of the judgments. We'll consider it certainly.
No, will it be inconvenient to give me one opportunity, my lord?
No, in fact. since we
Or
have-
just about
we have
15 minutes on
already
a
heard
day, particular day, my lord.
Right, but
15 minutes, maybe tomorrow also.
okay, tomorrow.
Tomorrow.
Which part of tomorrow?
ऐसा वर्जिन में हिंदी का जो हिस्ट्री है इन्वेस्टेड राइट
Admission नोटिस करके उसके साथ में
Yes.
I don't know. No, I don't know. I think some matter.
Goswami has come from Delhi.
Can we?
Mr. Manish Goswami has come from Delhi.
Yeah, no, I'm just,
At the
can
cost
we
of-
permit it to mention it? Lord?
Yeah.
Rising?
Mention the matter.
I think item 27.
27, yeah.
Yes, Lordship, is a very short matter pertaining to termination of certain employees.
That is, this item number 30 is also
Yes, that's what Lordship is
connected appeal.
subject to your Lordship's convenience. Since the bench is rising today, can it be taken up next week on 30th? Subject to your Lordship's convenience.
30th.
It's a very short matter, won't take much time.
Oh, 30th, in fact, we have fixed one more matter.
Item 30, my lord. It is item 30.
Yeah, that's right. Item 30 is
Admit,
similar appeal are listed at 27, 28 and 29.
Yes, Lordship, that's
My
clear.
lord.
I am appearing for
But
two and
my- My appeal is not admitted yet. Kindly admit and tag with these matters.
Yes, that we can do. But so far as regarding fixing of date is concerned,
First, third June को लगता है।
इसमें item number 30. Who is appearing for the this respondent in the item number 30? Health Department, yes. Who is the counsel for the Health Department?
Wait, नाम लेते हैं। Mr. Yesterday he was there.
Okay, in this matter, the item number 30, admit. Mr. D. Gogoi accept notice on behalf of all the respondents. No need to issue formal notices. List this writ appeal along with writ appeal number 429/2023, 428/2023, and 453/2023 for the hearing on 3rd of June.
My lord, may I request one thing, my lord?
Yeah.
In this writ appeal, 429, your lordships granted interim relief. If the posts are vacant, that should not be filled. I am seeking the same relief, the same order.
Let us see, sir. Now we are fixing it for hearing. In other appeals also, there is a stay order.
Yes, my lord. In all the matters, my lord.
The 3rd June.
The same. Kindly have a look on 4th December 2023.
Yeah, there is a order in my favor. Lordship, instead of 3rd June, can it be 5th June?
5th June, in fact, 5th June,
Both from 27 to 30, all 4 matters.
just a minute. Is that order in the
4th December.
429/2020 was the interim order.
হয়তো একটু বন্ধ হয় वो नहीं है
Next order, then till the next returnable date, the respondents are directed not to fill up. How many posts?
My lord, there are
There-
89 posts in, my lord.
17 posts, they're held by
Yes.
the.
So that is, the first order was passed in my case, where there were 17 appellants. So therefore, the court made it very clear that.
How many appellants are there in your case?
My lord, 89.
The post claimed by the appellants.
Till next returnable, the respondents are directed not to fill up 89 posts held by the appellant is still vacant till the next returnable day.
I am grateful, ma'am.
Till next date,
item
they are
number-
not returnable
Lordship is
date,
skipping
since we have not made the notices returnable till next date.
Lordship is keeping it on 5th of June.
5th of June.
I'm so grateful. So
I am
good.
grateful. ma'am.
Item number 11, if your lordship can take it up on 11. 11, item number 11. If your
Item
lordship-
number 11.
Yes, we
Yes,
have
ma'am.
agreed, my lord, for 11th of June.
For 11th.
11th of June. It's a Tuesday.
Okay, fine, 11th. Yes, Mr. Reji.
Item number 12 to 17, my lord.
Yeah, what do you?
12 to 13, I am the appellant, my lord. And 13 to 17, my learned friend is also there. So if the matters can be fixed after vacation, my lord.
Who is for the other side?
My lord,
You are
I'm there
Mr. Nahar is there.
On 25th July, 25th.
25th July.
At the request of both the parties, list this matter on 25th of July. List these matters on 25th of July.
12 to 17, my lord.
Yeah.
Please. On
Just
that
a minute, let him complete, yes.
Let the hearing be done and then order be passed. No, not it.
And the hearing will be done. That is why the matter is being fixed. Please try to understand.
Okay, Lord.
He is appearing in those.
No, he is appearing for the
Item number.
item number 17.
17, yeah. 25th of July. We have
12
fixed
to
the-
17, my lord. 12 to 17, item number 12 to 17.
Yeah, 12 to 17, at the request of the learned counsel of the parties, these appeals on 25th of July 2024.
I am obliged, my lord.
Deeply.
Lordship, may I mention item 21?
21, yeah.
It's a writ appeal, your lordship, and subject to the convenience of the honorable court, may I request it can be taken up on 11th or 13th of June?
Date of your convenience.
11th?
11.
Deeply obliged.
Daily list for orders, item 1.
It appears. There is a multiplicity of litigation in this case, my lord, by a miscase. Now it appears, my lord, the Food Corporation of India has also filed a review petition. Now it will have to be seen whether this type of review is maintainable in case of a writ appeal which was dismissed on withdrawal. And anyway, I am not been given the copy. Our senior gave me a call.
This is matter number.
Review is given. It is item number 2, I think, my lord.
Earlier, the review was filed by the they had filed a while it was filed. Now F3I has filed an application taking we also want the review of the order. On the ground that the withdrawal on the basis of the submission rate is like that.
Now I have been given a copy, my lord, now review. I think, my lord, the matter, all these matters should be heard at some length, and my lord, there should be an end to all this matter. That's what I pray right now. Apparently, it is a review. In respect of judgment and order, Lordship may have a look at the judgment and order dated 27/2. Forget about the observations. Come to the second page. After careful perusal of provisions, contract as well as the impugn order, we find that
First, let them, you're for the opposite party in the IA.
I am for the petitioner, my lord. The writ petition, my writ petition was allowed by learned single judge directing FCI to refund certain money.
In this IA, you're the opposite party.
My lord, what happened? Original writ petition, my lord, the learned single judge allowed my petition directing them to refund the money, which they unilaterally deducted from other works.
They came in.
Then they came.
Right.
Then they submitted certain things, and it says during the be that as it may. That is my lord, how your lordship said. Be that as it may. Forget about everything. What their submission during the course of hearing, the learned senior counsel appearing for FCI submitted that he would like to withdraw the appeal, seeking liberty of this court to approach the appropriate forum, including redressal court.
Correct.
Then lordship gave this. Then lordship gave this. Contract was concluded 5 years there before. After 5 years, they unilaterally deducted some money from me in respect of that contract, which was concluded from my other works. Learned single judge said he cannot do it.
Withdrawal order is at page 20.
So this was dismissed, my lord, on withdrawal. Last sentence, the writ appeal is accordingly dismissed on withdrawal with liberty.
पहला वाला order बाद में है. After withdrawal. After withdrawal, it went to the GCC. Sorry, the redressal committee.
And then after this, what is this?
Then
7/8/2020.
7/8, they came before the court. The contractor came before the court saying that my amount should be released. There was a direction of the single judge. Appeal was withdrawn, so the amount which I was paying for should be released. So we decided that some collateral security is necessary at the request of the FCI. So we directed that you give a collateral and the amount can be released.
And my
Then
eye was
we
all
now
about
filed an application seeking review of the second order by the contractor. By the court. He says that firstly to review appeal was withdrawn by them. Once that is done, why is the occasion to give another direction to give a collateral security? But nevertheless, collateral security put me, I'll give a guarantee. So it was at that point the matter was to the court in several benches.
Then after
The
this
FCI
dismiss,
was not agreed. Now the FCI filed that withdrawal itself was collected.
then after this dismissal of the then after this dismissal of the writ appeal, they filed a miscellaneous application seeking some rider which was given by this honorable court, which again put me in some trouble, practical problem. I again came for a modification.
Why what modification you are seeking now?
My lord, I believe, my lord,
You are seeking modification in the order dated 7/8/2023.
no. 20 not, my lord, thereafter subsequent order was passed asking me that to file, my lord, submit certain solvency.
That is of 7/8/2023.
Yes.
Yes, you are seeking review of this.
Yes, my lord, solvency is really some cumbersome, my lord, non-refundable huge amount I have to pay. Moreover, it will be like putting the cart in front of the horse, presuming
Then why you have agreed for that?
by solvency.
Yes.
My lord, in view of the order passed by the learned single judge, and in view of the dismissal, on the dismissal of the withdrawal, the matter ought to have ended there. They didn't come for review at that time. They filed the miscellaneous petition on which somehow your lordship were pleased to give them the rider that all right, me to file. Now, my lord, me filing will be presumption that in the event they go to a civil court, they will get a money degree against me. Why, first of all, my lord, I should be put to give some security to them in respect of the money which they deducted, my lord, 5 years after conclusion of the contract.
Surety. Surety. That is bank, it's not bank, correct? But he's like, no, I'll have to, the bank doesn't issue like that. I'll have to deposit the equivalent amount, keep it in the bank.
So, and you are seeking review of what?
Um,
She gave me the copy again, she's taking it back. Please.
You are appealing for whom? You are appealing for
My lord, my senior is out of station, so I'm on the behalf of the petitioner, Food Corporation of India.
So how Food Corporation of India, when they themselves have said that there is a provision for this redressal committee to approach, and on your submission, this was you have withdrawn the petition. How now you can resile back?
My lord, annexure 3 and 4, you can see the reason for
3 and 4 of what?
annexure of 3 and 4 of the review petition. The why
The council, that the council is not. Yeah. This is a deeper. Council review petition. Item number
Review petition number 362.
my lord, IA has been submitted.
in this one, yeah, 3625.
Yes, annexure number,
Annexure number 3 and 4,
page.
page 178 and 179. My lord, actually GRC is meant for only contractor only. It is not for the FCI. FCI is not responsible for paying back the money. It is there is a citation in annexure 3 and 4.
Name not number. Interview. Yeah. It doesn't appear to be.
Point 1 and 2, annexure 4. My lord, it is written grievances redressal committee, time-bound disposal of the cases by the GRC. 1 and 2, it is written grievance redressal committee shall consider the matter only related to the contractors. That is the party to whom the contract has been awarded and not the bidders. The role of GRC shall cover the dispute arising due to the period of the contract. On the basis of the citation, this review petition has been submitted.
Where is the original clause? Where is the clause?
In
It was, my lord, cited by your lordship in the disposal of the writ appeal. 27 to 2003. And that provision they cited before the learned single judge also.
Nahi. That is their interpretation. That is their interpretation.
And this clarification also says that grievance redressal committee shall consider the matters only related to contractors. So where is the prohibition that you can't apply the grievance redressal committee?
Yeah.
My lord, I think I have to adjourn the case.
Here, my lord, in your lordship's order 27-2, the clause 20 is quoted. They have a dispute redressal forum. When there is a dispute, the contractor may choose. This is meant by FCI's officers.
Now, as per this clarification, now they are saying that only the contractors can approach the grievance redressal committee, but we don't find any such.
Definitely, I would not prefer to go because my contract was concluded 5 years ago. There was no dispute during the currency of the contract. No dispute. All bills were paid to me from 2015 to 2017, 2 years. I undertook the contract work, finished it. Bills paid, securities refunded. Suddenly, after 5 years, there passes an unilateral order that no, indeed, the distance mentioned in the NIT and work order was wrong, 6 kilometers short. Therefore, we recover from other works.
You supply the copy of the this review petition to them. You are not in receipt of the copy of the this.
Not yet, my lord. He gave me one. By today.
My senior told me to give a review petition to you also.
Your senior told me to give one. Then give me one. Huh? Or or should I get it there?
I don't know actually.
Next time, my lord, apparently, my lord, this multiplicity of litigation should be ended.
Whenever the next this bench is assembled.
No, should indicate that the entire origin.
At the request of the learned counsel for the parties, these matters be listed before this bench whenever. Whenever it is available.
Copy may be supplied.
Copy they have supplied, you know?
Not yet, my lord.
Supply copy when you are offering, why copy of the review petition, counsel appearing for the Food Corporation of India is directed to supply copy of the review petition 3625/2024 to the counsel for the private respondent.
So, my lord,
During the course of the day,
what I pray, my lord, on the next date, my lord, the matter may be, the appeal was disposed of last year, February. So huge amount of money is being blocked. Now, lordship may put to end all this, my lord, multiplicity of litigation.
So what we are sitting now, you are seeking adjournment, we are here for putting an.
No, my lord, I never took it.
Okay, yes, next.
I never, today also, my lord. I never took it done.
We'll attempt on the next day.
That's what, my lord.
Okay.
After single judge who directed, I am not yet getting the benefit, my lord, because of the rider. And no, lordship may hear on merit also the main case, my lord. How I was agreed.
Certainly here, let you people be ready for argument.
Yes, yes, my lord.
Then certainly hear you.
Yes.
Item number 3.
Oblige, lordship.
May I please your lordship? Lordship, this review application is regarding review of the order dated 14/12/22, lordship. Lordship, the order starts at page 18, lordship.
1/8.
1/8, lordship, 18. And the operative part is at page 19, lordship. The second para, lordship, may I read?
Yes, read.
The second para, feeling aggrieved and dissatisfied with the judgment and order dated 30/9/2022 passed by the learned single judge in WPC number 1441 of 2021, the original petitioner has preferred this intra-court appeal. Considering the directions issued by the learned single judge, more particularly in paragraph 47 to 50 of the impugned judgment, we are informed that the bar that the said order has already been implemented in the sense that remand proceedings have culminated into a order of final settlement in favor of the respondent number 7, which was the subject matter of challenge by the very petitioner before the learned single judge in WPC number 1441 of 2021. Lordship, this 1441 of 2021, that ought to have been WPC number 5784 of 2022, Lordship. Because, Lordship, the order dated 30/9/2022, the single judge's order that has already been complied, Lordship. By order dated 17/10/22, and that is the subject matter of challenge in WPC number 7584, which is pending for adjudication, Lordship.
Who's for the other side?
Lordship, the other side, Lordship, the names are not shown, Lordship. The fisheries, by mistake, revenue department has been shown in the cause list.
नहीं इसमें क्या है कि they're saying that ये जो subsequent वाला reference है, the order of settlement in favor of so and so, which was the subject matter in the light of the above, ये it should be reflected as some other explanation. ये जो writ appeal है, the writ appeal arises out of 1441. Then considering that more particularly is going to be informed, order has been implemented. दूसरा
So what do you, what do you want?
Lordship, the WPC number 1441 that has have again come before the single judge, Lordship. That 1441, Lordship. Because of this one typographical mistake, Lordship.
This is the typographical mistake
Lordship,
and nothing else.
Nothing else, because Lordship, the order has
So
already.
you mean to say that in this page number 3, which was subject matter of challenge by the very petitioner before the learned single judge in WPC number 1441 public 2021, instead of it some other number.
Instead of WPC number 7584, that ought to have been 7584, because the said order has already Lordship complied, and that is challenged, and it's already pending.
That is under challenge there.
That is under challenge and pending, Lordship. Pending.
So how it will make effect even if this correction is there?
Lordship, because that has been revived again. The 1441 has again come before the single judge, Lordship.
Again come before the
Lordship. That is the main problem.
How it can be different?
The writ appeal order was passed in against the judgment arising out of 1441.
Lordship.
And there is another writ petition that is 7584
Lordship.
2022, which is pending,
Lordship, that is
where you are permitted to go and agitate.
Lordship.
You are facing any difficulty in that?
Lordship. Only because that has been already decided in the writ appeal, that has
So
been
it has
revived.
been revived. Who said it revived?
Lordship, it has come, Lordship. It has been listed in the cause list. Lordship.
Along with this 7584.
Lordship, that is also pending. That has also come, and 1441 is also has also come along with it, Lordship.
Who is for the other side?
Lordship, we have served copy, but the names are not shown today. Lordship, may issue notice. Let them come.
You short copy to whom?
Lordship, the other side, Lordship, the other fishery, respondent fishery.
Name.
Oh, Lordship. Lordship, respondent number 7, Lordship.
Respondent number 7, you have served the copy to whom? Which advocate?
Gauripur Cooperative Fishery.
No, advocate.
Mr. DJ Medhi, Lordship, he was there. Lordship, may issue notice, let them appear.
Name of Mr. Vijay.
Let's just review application. Before this bench on before this bench on its availability, while reflecting the name of Mr. DJ Medhi as counsel for the respondent.
Lordship. And also the as standing counsel fisheries name may be reflected, Lordship, instead of revenue and disaster.
And the standing counsel of the fisheries department.
Lordship. Much obliged, Lordship.